The crazy part is, I didn't find out someone stole 1,800 acres from my family because they got bold. I found out because I was trying to save a few points on an interest rate, like some ordinary Tuesday grown-up chore. One phone call later, I'm staring at a deed that says my land got sold for $2.3 million by people who didn't own a single square inch of it. It was February, Atlanta winter, that flat gray light where the city looks like it's been washed in dishwater, and I'm up on the 14th floor of my old Midtown office, the one I kept after I retired, because trust work doesn't retire, it just follows you around like a polite debt. Piedmont Park sat outside my east window, trees stripped down to their bones, and I'm doing what I've done 100 times, refinance, update valuations, sign the same forms in slightly different fonts. Routine. Then the title examiner calls. Thomas Reed, senior guy, steady voice, the kind of man who has built a whole career on catching the one thing everyone else misses. And I hear it the second he says my name, that careful tone, not panic, not drama, just caution, like he's holding something sharp and doesn't want either of us to bleed. Ms. Vance, he says, I'm running the ownership search on the Pinehurst Commons parcel. The 1,800 acres, there's a recorded deed transfer on that property. I stop moving completely, pen hovering above paper, like I'm suddenly in school again, and the teacher just asked a question I can't afford to answer wrong. Read it to me. He does slowly. The grantor listed is the Pinehurst Commons Community Association, the HOA. The grantee is Crescent Land Partners, LLC. Consideration stated, $2.3 million. Recorded October 14, 2022. I felt my stomach do that cold, quiet drop, not fear exactly, more like recognition. Like my body knew what my mind hadn't accepted yet. Because my family has owned that land since 1951. My grandfather bought it with 20 years of saving, and the kind of stubbornness you only get after being told no enough times that you stop asking permission. 7 banks turned him down. 7. He finally found an 8th, a black-owned bank in Atlanta that looked at a black farmer and saw an actual human being with a plan. He recorded the deed on April 3, 1951, Harmon County, Georgia, and it stayed clean, passed to my father, passed to me, then into the Vance Family Land Trust. 73 years of unbroken chain, tidy as a braid. So when Thomas says gently, the HOA doesn't appear anywhere in the chain of title as an owner, I don't argue. I don't ask what he thinks. I already know what it is. Send me everything, I tell him. The deed, the notary, the recording page, everything. For minutes later, it lands in my inbox. 12 pages, formatted like it belongs in any closing folder in Georgia. Warranty deed. Proper captions. Proper exhibits. Proper survey description, and that's the part that hit me like a slap. Because the legal description wasn't vague. It wasn't a sloppy guess. It was my land, down to the same metes and bounds my grandfather recorded back when men like him had to be careful about everything, where they stood, who they spoke to, what they signed, who witnessed it. The notary certification was real. Commission number checked out with the Secretary of State. The recording stamp was real. Harmon County Superior Court Clerk, Deed Book 847, page 223. And then page 11, the signature page. Mitchell A. Greer. Blue ink. Confident cursive. The signature of a man who signs things because he's used to people obeying them. Under it, President, Pinehurst Commons Community Association. A witness. A seal. Every box checked except the only box that mattered. Mitchell Greer didn't own my land. The HOA never owned my land. They'd been living on it, governing over a community built on it, collecting dues on it, for decades, but ownership? No. Not once. Not ever. Here's what Pinehurst Commons actually was. In 1989, my father negotiated a ground lease development agreement with a developer named Harold Stern. Stern could build homes, sell the structures, make his profit. The land stayed in our trust forever. Homeowners own their houses, not the dirt under them. The HOA's authority came from the ground leases and the community's governing documents, rules about fences and paint colors and pool keys, not the right to sell a county's worth of land like it was a used sofa. So I sat there in my quiet office, the park outside looking dead and honest, and I didn't call the HOA. I didn't call Mitchell. I didn't ask for clarification. I did what 40 years of real estate law teaches you to do when somebody hands you a lie dressed as paperwork. I built a case before the liar even knew I'd woken up. I called Catherine Oates. Catherine's a property litigation specialist, the patient kind, methodical, the kind who can peel a fraud open one layer at a time without ever tearing the evidence. She answers on the second ring, and before I can even finish the first sentence she goes, "Eleanor, what's wrong?" "Someone recorded a fraudulent deed on the Vance Trust land," I say, keeping my voice level because my whole career taught me that when your voice shakes, men think it means you're unsure. "Pinehurst Commons, 1,800 acres. There's a pause, then keyboard clicking, the sound of a professional shifting into motion. "How fraudulent?" she asks. "The HOA doesn't own the land. Never has. Greer signed a deed transferring it to an LLC for $2.3 million. Any closing statement? Title insurance? Transfer tax?" "No. Nothing. Just recorded." That was the first twist of the knife, honestly, because it told me this wasn't a mistake at a sloppy closing table. This was someone sneaking into the public record like a pickpocket slipping a hand into your coat, then walking away whistling. Catherine tells me deed fraud on recorded title is a felony in Georgia, and I tell her, I know what it is. Then I say the part that mattered most. I want everything documented before he knows I've found it. Because the order of moves matters. Always. The first filing shapes the battlefield. The first disclosure tells the other side where to aim. 53 minutes later, Catherine calls back, and her voice has that evenness attorneys get when they're delivering facts that are going to ruin somebody's life. "Creston Land Partners LLC, she says, registered November 18, 2021, single-member LLC. I'm already doing the math in my head, 11 months before the fraudulent deed gets recorded. "Who's the member?" I ask. She exhales once, like she's handing me a weight. "Derek Allen Greer." I close my eyes for a second. "His son." "His son," she repeats, and now the whole thing isn't just fraud, it's a family business plan. A father using a community position like a crowbar, levering his way into someone else's title, handing it off to his kid like a trophy. And then Catherine says, the $2.3 million was never paid. No wire. No cashier's check. No mortgage. No survey ordered. No title insurance policy. The number on the deed is false consideration, meant to make it look legitimate. So here I am, looking at a deed that says my land was sold for money that never existed, to a company formed for no reason except to catch stolen property. What was he planning to do with it? I ask, and Catherine shuffles papers. That's the third thing, she says, and I hear the smallest hint of disbelief even in her voice. In February 2023, 4 months after the deed, Creston approached a commercial developer, Apex Growth Partners. Proposal for 340 acres, mixed-use corridor, retail, hotel component. Valued at about $8.4 million. 8.4. For land they didn't own. For land they never paid for. For land they bought on paper for $2.3 million, then tried to flip a portion of for triple that. The only reason it didn't work? Apex's title examiner did their job. Pulled the chain, saw the clean 1951 deed, saw the ground lease structure, saw the HOA nowhere in title, and walked away quietly. No lawsuit, no press, just gone. And Mitchell Greer, instead of unwinding the fraud, leaves the deed sitting in the public record like a landmine, thinking silence is safety. That's when my anger went from hot to cold, because 220 families lived in that community, paid their mortgages, paid their dues, went to HOA meetings. Trusted the president who smiled at them in the clubhouse while he tried to sell the ground under their neighborhood to a developer like he was cashing out a casino chip. Catherine and I spent 3 weeks building a file so clean it could cut glass, certified corporate records, title examiner affidavit tracing ownership back to 1951, HOA financials showing no money, board minutes with one lonely line in October 2022. President Greer reported ongoing progress on the community land status resolution. Details to follow. Details never followed. Funny how that works. We filed a quiet title action, asking the court to declare the deed void from inception, void ab initio, because you cannot convey what you do not own, period. We sent a criminal referral to the Georgia Attorney General's office, 47 pages of evidence, statutes lined up like dominoes. And then, because I wanted this to land where it would actually hurt, we sent termination notices under the ground leases to Mitchell and 4 board members who had signed a resolution giving him authority to resolve the land status. Not a termination yet, a notice of review and intent, 21 days to respond, consult counsel, do something other than pretend. They did nothing. That was their choice. And people like Mitchell always think the most dangerous thing in the world is someone raising their voice. They don't fear quiet paperwork. They should. Mitchell finally called me after his lawyer called Catherine, after the filing went public, after his story started collapsing in real time. His voice was controlled at first, like he could still steer this with charisma. "Ms. Vance, there's been a misunderstanding." "No," I said, calm as a surgeon. "You recorded a deed transferring 1,800 acres of my family's land to an LLC owned by your son. The HOA never owned that land. The money was never paid. You then tried to sell 340 acres for $8.4 million. Silence. Then he tried the angle that always shows up when a man runs out of truth. We were trying to stabilize the land situation by recording a deed to your son's shell company," I said, and you could hear his narrative hit a wall. "Please fight it." And I hung up. Here's the second twist, the one he never saw coming, the one that turned his fraud into karma with a return address. Once the response period expired, I assigned the ground lessor interests on those 5 lots to a firm called Meridian Land Capital. They specialize in enforcement. Not theatrics. Not threats. Just methodical consequences. The assignment was signed April 3rd, 73 years to the day my grandfather recorded his deed. I didn't plan that, but when I saw the date, I let myself smile for the first time in weeks, because sometimes the universe doesn't fix things for you. It just lines up the ruler and says, "Go ahead." Meridian sent certified letters. Mitchell got his on April 5th and panicked, so hard his attorney called Catherine just to confirm it was real. It was real. Meridian now held the ground lease position under his house. And once Meridian executed termination, after notice, cure period, all the required steps, Mitchell owned a structure with no legal right to sit on the land beneath it. A house without land under it is a very expensive shed. His lender did what lenders do. They reassessed collateral. They saw a $780,000 home become a relocatable structure, worth maybe $210,000. They called the loan. Suddenly, the man who thought he could steal land with a signature was learning that banks don't care about his pride, they care about security interests. Meanwhile, I did the part one should have done years earlier. We sent a plain language community notice to all 220 households explaining the ground lease structure, the fraud, the fact that 215 families were not in breach and not in danger, and what steps were being taken. And we held a community meeting. That night, the room was packed, people standing along the walls, and the surprise person who changed the whole temperature wasn't a lawyer or a board member. It was Margaret Chin, a retired financial analyst who basically became the neighborhood's human spreadsheet. She had organized the room, gathered questions, calmed panic, and when I finished explaining, she stood up and said, steady as stone, "So the truth is we've been living on leased land this whole time, and one man tried to sell it out from under us." You could hear 100 people inhale at once. And that's when the moral hit me. Not the preachy kind, the kind that arrives like a bruise you didn't notice until you touch it. Power loves invisibility. It feeds on it. Mitchell Greer felt bold enough to record a fraudulent deed because the real owner was a name on a check, not a person in the room. I had been passive, assuming honesty would keep itself alive. And the bitter truth is, honesty isn't a self-sustaining system, it's a garden. If you don't show up, weeds don't hesitate. The courts moved fast because the documentation was clean. An indictment came down, Mitchell on 4 counts, his son on 2. Derek pled and cooperated. A son testifying against his father. I didn't feel joy about that. It wasn't the point. It was the bill coming due for involving your child in a crime built on other people's history. Civil court hit him too. Damages, punitive damages, attorney fees. A judge wrote, in black and white, that Mitchell didn't fail because he chose to stop, he failed because a title examiner had a conscience. And the final, sweetest detail? The fraudulent deed, Deed Book 847, page 223, was expunged. The clerk stamped it void ab initio. Then I printed a photo of that annotated page and slid it behind my grandfather's original 1951 deed in the trust file, like a quiet little trophy proof that the deed outlasted the opinion again. Mitchell went to prison. His civil judgment followed him. The rest of the community got new ground leases, longer term, title insured, plain language summary on page 1 so nobody could ever claim confusion again. The neighborhood didn't get perfect, but it got honest. And me? I learned something I wish I'd learned earlier. Being right on paper doesn't protect you if you stay invisible in real life. The law is powerful, but it's not psychic. It works best when you show up, keep records clean, and refuse to let someone else narrate your silence as weakness. So here's the question I want to leave you with, because it's the part people argue about. When someone abuses power and tries to steal what isn't theirs, where's the line between justice and revenge? And does it even matter if the consequences are completely legal? Drop your take in the comments. Tell me if you think what happened to Mitchell was fair, too harsh, or exactly what was coming, and if you've ever dealt with an HOA, a property dispute, or somebody in a position of trust who thought they could get away with a quiet little fraud. Share your story too. Because I promise you, someone reading it needs to know they're not crazy for fighting back.